My name is Gary Drury. I'm from Lee Veritas. I also have my associate Beth Lazaro on here, who is also from Lee Veritas and BankruptcyFIDO. We present to individuals across the country regarding a number of topics in the debt area, whether it's bankruptcy or any type of credit issues that individuals have. We bring experts online to answer questions. These webinars are free. If you choose to use some of the professionals that we have that present is purely up to you. There is no obligation for that. This is strictly educational, and the information that we are giving is legal information, not legal advice. Please consult an attorney if you need to regarding your individual cases. You will have an opportunity to ask questions online for us to be able to answer and respond to. Ted Taggart is a Colorado attorney for bankruptcy and other debt-related issues, including debt settlement. He has attended a number of workshops with the trustee's office in Colorado, has given some excellent advice, and this is one of the reasons, as well as his high rating with clients, that we have referred to him in these types of programs. Ted, welcome to this program. Appreciate you coming in. I'm going to summarize here the presentation that we have, because I know that you are not looking directly at the presentation. We were talking about balance transfers, personal loans, credit counseling and debt programs, debt settlement and bankruptcy. What are the things that we should do? What options should we look at? And what would be the best advice from you as an expert in the market for individuals? And try as much as possible to do this from a consumer's point of view. What, if you were a consumer, what do you feel like you would need in relationship to this?
Well, the first thing I always tell folks when they come in, I mean, they obviously didn't win the lottery, so they have some financial issues that are weighing on them. And obviously one of the things that I have to look at is bankruptcy a good idea or not? Are other options the right thing to do? Not nearly as bad as people think. The other options like debt settlement or consolidation or credit counseling, that sort of thing, are typically a good idea if you have assets that might be subject to being lost if you were to file bankruptcy. The vast majority of cases, that's just simply not the case. And by the time that they are in a position to seek some sort of help, whether it be bankruptcy or another program, typically their credit is usually pretty damaged. Very few people start to deal with these issues with pristine good credit. That's just a fact. So I start with the idea, the presumption that probably bankruptcy is going to be the right thing. Why? Again, because the damage is already, the credit's already damaged. The assets they typically have are probably, in most cases, going to be protected in bankruptcy through something called exemption. That means they're protected even though you're filing. And because their credit's already bad. And fourth, and almost most importantly, is that your credit can recover much more quickly than most people realize. You can get your credit score back up to the 700s within 2 years. You can qualify for an FHA home loan 2 years after discharge if you do the right things between your filing and that date. So as a general rule, bankruptcy is something that is not to be scared of. It's usually a better idea than most people think it is.
Thank you for that. One of the initial options is regarding the credit is good and there is outstanding debt is low, whether or not all of that can be transferred into a single low-interest credit card. If a person's credit is good, would you recommend, if a person sees some issues in the horizon, that they transfer to a single low-interest credit card, or what would your recommendation be?
That is smart. There's absolutely nothing wrong with it. But again, for my purposes, when I help people, it's typically not an aggregate amount of debt that's all that low. But if it is, you just don't have enough debt to warrant the bankruptcy, that's a smart thing to do, for sure. There's no question about it.
How likely is it that banks are willing to give unsecured loans in order to pay off the other debts, to consolidate those debts for you? Do you know what is a moderate to a good credit rating and asset value for banks to provide unsecured credit loans and for you to be able to pay off your excess debt?
Well, you gotta have to have excellent credit.
Mm-hmm.
I mean, I don't know what the score will be. I can't speak to every bank, of course, or credit union, but you're going to have excellent credit. I mean, think about what you are asking the bank to do. You take a risk so you can pay off other creditors. That is one of the least favorite uses of money upon which banks like to lend, because you're not getting any growth out of the money. You're using it to pay other debt down. Banks typically don't like that. So if you're going to get that kind of loan, you're going to have excellent credit. And that might not be what's going on here. I mean, if people are in this workshop, they probably don't have excellent credit. Probably not a likely scenario.
How do you feel about credit counseling and debt management programs? Now, this is different from credit consolidation or debt settlement. What's your feeling about those third-party nonprofit organizations that will lower your rates, manage your debts, basically not negotiate, but bring down that interest rate for credit cards and credit companies because they have a direct relationship with them? What is your opinion about the credit counseling solution versus the debt settlement or debt consolidation solution?
Well, I don't have a problem with it per se. Okay, I mean, they're not bad programs. As long as you have to double check to make sure it's a reputable program. And again, these are not debt consolidation folks. But before, and this is really big advice, before anyone even begins to think about something like that, my advice would be to seek out a bankruptcy. It doesn't mean that you have to file bankruptcy. A good, ethical bankruptcy attorney will tell you whether or not that program is going to be a wise course of action, or whether you're going to part with a lot of cash needlessly. If bankruptcy is the right course of action from a cash flow point of view, and because you don't have a lot of assets and all the other things I already talked about, the program, although not terrible on its face, may not be the wisest course of action. So what I don't like to see people do is jump into these programs because they have a knee-jerk reaction to avoid bankruptcy at all costs. You've got to get out of that mindset.
Thank you. How would a consumer determine whether or not a bankruptcy attorney has a self-interest in having that consumer file bankruptcy versus the alternative programs of credit counseling?
Well, good question. You know, for me anyway, I'm one of the few bankruptcy attorneys that also does debt settlement. Now, I have different than the credit counseling, as you know, but I don't have an inherent bias in my case. So you might want to look for people who will do something other than bankruptcy. The other thing is a potential client, you have to ask the questions why. If someone says, hey, bankruptcy is for you, don't take it at face value. Ask why. Have them explain why it's a good idea. And if it is a good idea, he should be able to articulate that.
Thank you. And how is there a calculation or a chart of some sort to be able to determine what a person should do, or is it more subjective than that?
No, it really is a case-by-case basis. One of the litmus tests I use is two basic key questions that begin the analysis for me. Number one, how important is your credit and what's your credit score? For some people, credit's not all that important. They already have a house. They already have their car. They're 60 years old. Very different thing than from a 30-year-old who wants to buy his first house. That's the first part of the little litmus test I start with. The second one is, can you pay off your current debt levels, whatever it may be, within 2 years without suffocating your life? If the answer is no, then you really have to question the wisdom of parting with that kind of cash. The 2 years comes from the fact that that's about how long it will take to rehabilitate your credit. So if you can rehabilitate your credit in about a 2-year period without parting with a ton of cash, which would really hamstring your lifestyle, then it's probably something that is a good sign that bankruptcy is a good candidate for you. But to go back to your original question, it really is a case-by-case basis, and that's why you really need to talk to a decent attorney. It's not a one-size-fits-all thing at all.
Thank you. Give us your position on debt settlement versus credit counseling versus bankruptcy. When would debt settlement apply?
Debt settlement doesn't apply all that often. I mean, those TV commercials that people see that are advertised on TV quite a lot, they have about a 2% success rate. They do not stop the litigation process. In other words, while you're in this program, your creditors can still sue you and garnish you. And if you have so much debt that you can't pay it off before someone sues and garnishes you, what's the point? As a general rule, those are really bad programs. Now, I do it sometimes on a case-by-case basis. When are those circumstances? Those circumstances typically are when you have assets that you might typically lose in a bankruptcy. For instance, you might have over $60,000 of equity in your home. $60,000 is the exemption level in Colorado. Every state's different. But Colorado is 60. Or you have other types of assets that will be subject to loss in a bankruptcy proceeding. And even if that's true, you do have assets, but Chapter 13, which is a different type of bankruptcy that can help you protect assets, still, in most cases, is going to be a better idea than debt settlement. Debt settlement's a rare thing, to be honest.
Well, you mentioned some of the aspects of bankruptcy. So tell us a little bit more about bankruptcy, the difference between the Chapter 7 and the 13 bankruptcy, and which one would be preferable in what conditions?
Well, the biggest difference between the 7 and the 13 is that the 13 requires monthly payments of, to a to-be-determined amount. A lot of factors can go into what your payments would be, from anywhere from 3 to 5 years, depending on your circumstances. There are a lot of things that you can do in a 13 that you cannot do in a 7. So, again, you have to look at particular circumstances. I'll give you one example. In a 13, you could, if the numbers work out just right, get rid of a second mortgage altogether. You cannot do that in a chapter. A Chapter 13 sometimes is required if you make over a certain amount of money, depending on your household. It's called the means test here in Colorado. And if you are above that means test by a significant amount, you're going to be a 13. That's what the law will require. So again, it's a case-by-case basis. As I mentioned earlier, one of the reasons you might go into a 13 is to protect some assets that you would otherwise lose in a 7.
Thank you. There are individuals on the line that are in real estate broker associate for one, and a question was asked related to bouncing back or bringing back up the credit for individuals that he has in his group of potential buyers. What would you recommend as the short course or the short process for someone reestablishing their credit, and then in specific, if a person has a short sale, has performed a short sale on their house, which has damaged their credit, how could they get their credit back up where they can purchase a house in what period of time?
Well, I am not an expert in credit rehab. I do refer that part of the process out. There are people who specialize in credit rehabilitation. Usually that's for people who have the purpose of trying to buy a home after bankruptcy. Now, obviously, when you have a post-bankruptcy situation, your credit can be rebuilt, but it also to make sure you pay your bills on time. If you do get a secured credit card rebuilt, and if you do get a secured credit card, if at all possible, you want to get it with a balance of a couple $1,000s. A secured credit card of $500 does not really demonstrate tremendous ability to manage debt because it's just not that much that you're ripping. But making sure you pay your bills on time. Diligent. Taking out some credit after that. You want to take little bite-sized chunks of credit that you can rehabilitate it. You want to be able to demonstrate to any future lender that you are recovered and have learned your lesson, so to speak. And quite honestly, if you want to rebuild your credit to buy a home, what you want to do, I would really look into a credit rehab. Folks, they monitor your credit score, which you really have to do post-bankruptcy to make sure it's recorded as discharge, which sometimes creditors don't do. You got to stay on top of that. And so those are some of the things I would do. But again, I have to emphasize, I am not a full-blown expert in that area.
Let's continuing on that vein with regard to bankruptcy, if a person is married and filing single, one spouse has not filed bankruptcy and the other has filed bankruptcy based on their various variants of credit, would it make a difference to purchasing a home?
Wait, let me try to understand this question. Does it make a difference on purchasing a home if one spouse files and the other one doesn't?
Correct.
Well, obviously, the person who doesn't file, their credit is not touched. Just because you're married doesn't mean you're attached to hip credit-wise. So obviously, that would be an advantage on obtaining credit. And of course, the other nice thing about it is, even though the other person's filed bankruptcy, they may not be on the loan, but they would be included in household income. So if the filing person, whoever that may be, is employed, they may not be on the loan, but they still can be counted as household income to help the other person secure the loan. But from a credit standpoint, the non-filing spouse's credit is not damaged simply by virtue of one of the other spouse filing.
Okay, I am going to have Beth Lazar talk to us, and she has some questions also from attendees. Beth?
I have Matt is asking, do any of these options apply if I owe the IRS?
It's possible. There are a couple of different ways you can deal with taxes. Now, it's a complicated issue that I'm not going to be able to get into every nitty-gritty detail, but for purposes of the discussion, it is possible to get income taxes, some certain income taxes, discharged in bankruptcy. Now, you have to meet at least 3 basic criteria, the most important one of which is that the taxes are over 3 years old. You obviously had to file these taxes. So even if it's from 2009, you can't have filed yesterday to get a discharge. Okay? 1 year has to be elapsed since the filing date, and the taxes have to be at least 3 years old. If you meet those basic criteria, you have a good shot. But you're not going to get a definitive answer in a discussion like this because that can be a very, very tricky part of the law.
Okay.
The other way you can deal with taxes in a bankruptcy situation sometimes, if you have a large tax and they're not dischargeable in a 7, you might want to consider using a Chapter 13 to pay the taxes because once you file, the interest and penalties stop. And if you've had a tax lien filed on you on all your personal property, that's non-dischargeable in a Chapter 7 because the lien has been attached to property. But in a 13, you can cram it down. In other words, if you have a tax liability of $100,000 and your stuff is only worth $10,000, you can get rid of $90,000. It's called a cram down. So you have a lot of options when it comes to the IRS. Just again, case-by-case basis. But at least whoever Matt is, wherever he is, I don't want him to fall victim to a common lawyer mistake that taxes are not dischargeable. A lot of inexperienced lawyers will just knee-jerk say that. It's not true.
Okay, I have a Lacey who is saying that she has credit card debt from a divorce and is asking if there's any way to get rid of that.
Well, you have to look at the divorce decree first. Well, first of all, the short answer is yes. But you have to look at the divorce decree. If the debt was allocated to her pursuant to a court order, the judge says, hey, this is yours, then you can get rid of it, but only in a Chapter 13. You cannot discharge that in a Chapter 7. You also have to make sure that this debt, the allocation of whatever this debt is, it was not given the language in maintenance. In other words, sometimes a person will say, in lieu of maintenance, this person will pay the debt. If it has that kind of language in the divorce decree, then there's nothing you can do. Maintenance is not dischargeable thing.
Thank you. I'm going to jump over to Michael for the next question, see if we have any questions that Michael wants to ask. Michael, are you on the line?
Yes, I'm on the line.
Okay. Let's see if we can get your questions answered and see if I answered or asked your questions correctly regarding real estate. Did you want to rephrase any questions or ask any other questions about being a real estate broker?
You addressed them pretty well about reestablishing themselves after after a short sale and/or foreclosure. It's reestablishing themselves. So I think that was what I was looking for.
Do you have any other questions, Michael?
No, not at this time. I don't.
Okay, Beth, questions?
I have a question here from James. Says, my brother used my name on a utility bill and then didn't pay. How does he wants to know how he can get his name off that bill.
Well, that's not a bankruptcy question. That's more of a contractual question. What he's going to have to do is send a dispute letter to the creditor, and quite honestly, it's anybody's guess as to whether or not that will succeed. Possession is 9/10 of the law, and the utility company, in some respect, has possession of the information. I mean, they say he owes, they report that he owes. It's an uphill battle, quite frankly, because you're asking the guy to prove a negative to a certain degree. It's nothing that any of the debt options that we had really talked about really address, because it's a one-off kind of unique circumstance where basically it's kind of an identity theft sort of deal, and that's a really tough slog. It's blunt about it, but it's just the way it is. You're going to have to just fight that with the utility company so you can keep it.
Beth?
Sarah is asking if these options that we talked about tonight cost money.
Sure. Everything costs money. But bankruptcy, it should be known, is probably one of the biggest bang for your bucks from a legal services perspective that you will find out there. Not that expensive. Depending on your circumstances, you're probably talking maybe a little under $1,000 in a very, very simple case to maybe $2,000 for something a bit more complex. But when you compare that next to all the debt that you discharge, all the stress that you're going to eliminate, it really is worth it. One thing on the price of most bankruptcy attorneys will give you flexible payment options.
Okay.
And no one expects you to walk in their office with $1,000 and plunk it right down. One of the things that I do, and I think good attorneys should do, is to help you buy time with your creditors, if you can, so that the person can manage whatever fee is agreed upon in a more palatable way. Like one example, for instance, if someone is getting sued or they've been served with a summons to go to court on unpaid debt, well, I know how to deal with that. I can help you file an answer to the court, which will prevent a default judgment, which will buy you time. That's just one little trick of the trade. But that's what a good old attorney will do. He will help buy you time so that you can come up with the money on a more comfortable way.
This one is not specifically bankruptcy related, but perhaps you could address this for Lisa. Apparently she has a debt collector calling her, and she's saying they're tacking on extra charges on top of her debt, and she wants to know why that would be.
Well, you'd have to go back to the contract. So that's going to be, again, a case by contract may provide for that type of damages, something like that. But as long as it's not usurious, in other words, statutorily egregious, then it's probably going to be okay. Now, that being said, if you were to settle that debt, let's say the balance is $1,000, but $600 of it is late fee. Those are parts of the fees that they tend to negotiate a little bit more favorably. The higher the interest rate, the higher the penalties, you usually get a better deal on any debt settlement.
Okay, last question I have here so far is from Sam, and it says, so if I don't want to repay my debt, the best option is bankruptcy. Is that correct?
Probably, yeah. Again, case-by-case basis, but if you don't have the cash flow to service your debt and keep your credit score up, and if your credit is important, and by the way, one really important point on credit. Your credit's good, it's important, but it's not the holy grail. Cash is the holy grail. You want to be in a position to use a bankruptcy or whatever strategy you have to get rid of your debt. At the end of the day, a very big portion of it is preserving. And if this gentleman doesn't want to repay his debt, there's no other real option than bankruptcy. But it probably is going to be the smart option for him anyway. The odds say that.
Okay, thank you very much. Any other questions on your side, Beth? Michael, you are in the real estate business, and real estate is a growing in most areas of the country. What are you seeing in the marketplace regarding people trying to get homes? What options do they have? What legal needs do they have? And what are you looking for specifically in the clients that you have coming to you now? Do you see a lot of clients with disparity and issues, and you have to help them recover? Are you finding a lot of individuals with cash? Where are you placed when clients are coming through the door? What's the profile look like?
I'm getting a lot of clients now, potential clients who have emerged from short sale, managed to live with relatives or rent and save some money. They're coming in with a significant down payment, but the banks are still not being lenient as far as lending them money to purchase another home without having to wait out a 2-year period or sometimes a 3-year period with perfect credit or near perfect credit. Mm-hmm. So they're trying to find out a way to get around that or build their credit back so they can do that. Of course, I always advise them to pay their bills on time, for one, no matter how big or small they are. But it's taking them time to do that. So, and all that short sale stuff that's been going on for the last 4 or 5 years is now people are trying to come back into the buying market. Because the market is coming back, especially out here where I live. I'm getting a lot of people who are trying to do that.
What are you seeing that people are doing that are successful, being able to find out a way to be able to increase or short
cut those issues? Coming in with cash, obviously, as Mr. Taggart had mentioned, cash is king. What do they come in with? 20%, 30%?
Yeah, 20, 25% down they're using, and even with that, the lenders are they have rules they got to go by according to what they tell me, that they have to wait so many months afterwards, a discharge of bankruptcy or 2 years good credit after a short sale. I do have one lender that was doing it 12 months after short sale. And then I've been doing a lot of owner financing, so trying to get people to buy with owner financing. But that limits the kind of homes they can buy.
Mm-hmm. Okay, good.
Pull out all the tricks in the hat.
Yeah, and those are all the basic tricks, owner financing, finding lenders that have, a shorter period of turnaround, 12 months, but they're rare, and higher cash down. Those are the 3 big ways that you've seen people becoming successful?
Correct.
Okay. All right, good. Okay. Ted, do you have any comments on those or any other comments related to real estate and what individuals can do?
Nope, he covered it pretty well.
Okay. All right, good. All right. Well, I really appreciate everyone in the meeting. I think that Ted Taggart has elucidated the options that we have available to us immediately. If there are any questions from individuals, especially in Colorado, please don't hesitate to email us, and we will we will pass Ted Taggart's information along to you. We have his email address right here, or his website here, coloradofreshstart.com, and his email is ted@coloradofreshstart.com, so that you can email him, and his telephone number is 303-339-0778 if you care to ask him questions or need his services in any way. Again, he does debt settlement, bankruptcy, and he is involved with a number of different types of legal practices. Don't hesitate to call him for yourself or for anyone that you may know, that may be having some debt or legal questions that need to be asked. In general, bankruptcy is a federal law, so most of the answers that Ted has provided, even though it is legal information, it is federal, so it's across the board. Of course, you must rely on specific local attorneys for legal advice when it comes down to your specific situation, and we do not hold any claim to providing you information that might direct you or guide you or advise you into what your solutions should be. Again, you need to provide yourself with an attorney or legal advice in your local area. If there are no other questions, I want to thank everyone for coming to the meeting today. And I thank you very much, Ted, for making yourself available. I know that you are out of the office and you're speaking remotely, and we appreciate you stopping what you were doing and coming into the meeting. Beth and Michael and so many others that have come into the meeting today, I appreciate your time as well.